Thanks for the introduction. Good evening, everybody. Does anyone own intellectual property in a robot's creation? So as Sean said, it's a really interesting topic about what happens when your robot, your artificial intelligence device, I'm going to keep using the word robot tonight, and forgive me because you know more about this stuff than me by a long shot. So if I'm not up on the jargon and the terminology, please forgive me, or humour me, or even teach me what I should be saying instead. But I'm going to say robots as a generic way of sorry, should I be standing here? Try not to stand in front of the screen. I'm going to use the word robot as just a generic way of describing sort of any sort of device, whether it's a robot, artificial intelligence, machine learning device that outputs some sort of I'm not sure if I'm allowed to use the word creation or not, but let's hold. I say that in a very technology neutral sense. Firstly, though, I did want to acknowledge, as we do at the beginning of all these presentations, any Aboriginal, Torres Strait Islander people who are here tonight. I think acknowledgements of country are really important. It's not something we should just robotically say. It's something that's actually substantively very important. Think about the kind of impact that this sort of technology might have on reconciliation and what we in the IP world call ICIP, Indigenous Cultural Intellectual Property. And I'm thinking of things like endangered languages or something like that. What sort of impact could this technology have? So start off on that note. Before I get into it though, I've got a big reveal tonight. You can see on the screen, you build robots, my kids build robots too. So I'll hold it up for the benefit of the camera. This is my new law firm mascot that my kids have helped me build after school. So 3, 2, 1. Oh, his antenna's gone all floppy. But he hasn't got a name yet. So if you'd like to put your thinking caps on and see if we can come up with a name by the end of the evening, that'd be really great because I'm going to keep him and drag him out at my presentations in the future. And I don't think I'm going to. Yeah, they do actually. That's my 6-year-old in there now. So I can get my head in like this, but I can't get my hands through the sleeves. So that's the new Stratocumulus Legal robot. I've sort of tentatively called him the Stratobot, but I'm sure we can come up with something better by the end of the evening. Do you remember this from a couple of years ago? It was in the news, I don't know, maybe even 5 years ago now. Does anybody remember this photograph? One hand over there. This was known in the news as the Monkey Selfie. And what happened was a photographer called, this is actually the sort of the news story that piqued my interest in this topic. Let me sort of tell you how it comes about. So a British wildlife photographer, whose name was David Slater, he was on a multi-day journey into a wildlife photography shoot in Sulawesi in Indonesia. And according to his story, and I take it at face value, but he got out into the jungle where there was a population of these, what are they? Celebes crested macaques, and they're endangered. And he was doing a wildlife shoot. He set up his cameras in the jungle, and over several days, he earned the monkeys' trust by taking photos of them. There's a whole troop of them. Somebody else gave this monkey the name Naruto later on. I'm not sure if the photographer actually wanted to call him that. The photographer, and what happened was the monkey learned, I guess through watching and observing, how the camera worked. According to the story, and I don't know if this is just made up afterwards or true, I don't know, let's just keep an open mind on it, but the photographer said he hoped this might happen. He hoped that the monkey might just come along and experiment and try pressing the shutter and he set it up for this to happen. Anyway, lo and behold, the monkey took a selfie and that's it. It's a pretty good photo actually. And there was a few others. The photographer sold the photograph to a British newspaper, and then quite soon afterwards, somebody, I assume from the newspaper's website, I guess that's how they got it, I don't know, uploaded it to Wikimedia Commons. And Wikimedia Commons only accepts materials that are in the public domain or over which somebody's not asserting a copyright license. It just public domain works. And the photographer was quite upset. He said, "Take it down, please. That's my photograph." And there was a bit of thinking behind it. And Wikimedia Commons website finally reached the position where they said, "No, human didn't take this. Monkey took this, and therefore there's no copyright in that image. We can do what we like with it." Thanks. It became a bit of a story. So that leads to the question: who owns copyright in images taken by a monkey? It also led to a US court dispute about whether monkeys themselves can own copyright. And I think that's where a lot of the media story came from. But what happens if a non-human or an animal takes a photograph? Who owns copyright in that?
What happened in the US dispute?
So let me just see if I can round it out before we get onto this guy. What happened in the US dispute was animal rights organisation PETA. I think they gave him the name Naruto rather than photographer. And Naruto launched a lawsuit in the US district for the Northern District of California, suing, unfortunately, the photographer, asserting that the monkey owned the copyright in the photograph. And the court case was dismissed. Animals can't own copyright. PETA appealed it to the Ninth Circuit Court of Appeals in the US. I'm not familiar with the US legal system, but it went to appeal. It settled on the basis that the photographer would donate 25% of his revenues from the photos to a wildlife charity. So it kind of worked out in a nice way. But the salient lesson from this is that the commercial outcome, apart from just having to, I think the photographer, he had to pay a truckload of legal costs and ended up financially a lot worse off than when he started, despite the good intentions of taking wildlife photographs and of an endangered species and promoting the cause. But the salient lesson is that commercially, if it's in the public domain, you lose control over it. And he said, his figures, he lost 10,000 British pounds in income due to the images effectively entering the public domain. Now, all that information I got from Wikipedia, so I'm taking at face value that it's true, but I think that's more or less what I remember reading in the news at the time. So, what if it's a robot selfie instead of an animal? That's sort of where my thinking started on this topic. Now, that's my 6-year-old inside this guy. I couldn't find a royalty-free image of a robot taking a selfie of itself, so I had to set one up. Maybe my son is more like a monkey than a robot at times anyway, but this was a really good sort of after-school project. I won't give you the whole details, but in my family, I'm the guy that does drop-offs, pickups, kids and everything. So when my little boy comes home at 3 p.m. and wants something to do, this was a great project, especially when I told him I was giving a talk about robots. So, but going back to what Sean said in his introduction, you as this audience will be far more aware than I am, but there are already lots of applications out there creating content. Maybe that's a better way than just using the word creations as I did before. The things that spring to my mind, and you'll have other things in your mind, is what if there's a drone, hovering over a paddock, taking images at various points on the paddock and using those images for sampling or weed control or whatever it might be in agribusiness, or it might be taking surveys in mining or resources, or it could be weather satellites, it could be the I won't name the company, but you know what I mean. It could be the car driving up the street with a camera on the roof taking a photograph automatically every 30 seconds. What happens to those photographs or images if they are purely automated and there's no human controlling it at all? Who owns copyright in those? Is it going to be the same outcome as the monkey? Where'd I hide it? Here we go. So there's a whole lot of applications at the moment where that sort of thing is starting to happen. Who does own the copyright in a satellite photograph of the Earth that's taken every half an hour or something to show the weather patterns? My little boy taught me all this stuff is also entering popular fiction. Anyone got kids? Anyone know the treehouse stories? So My little boy got this for Christmas. He loves these books. Andy and Terry's, this is the 39-story treehouse. It's the third in the series. Here we go. Chapter 4, the Once Upon a Time Machine. And so in this book, Andy and Terry build a machine that's going to write their book for them. And it's got dials and knobs, and you can, here's one. I can display an artistic work in public, can't I? Because it's not an exclusive right of the author of an artistic work. Not at all funny. Smile funny, politely funny, blah, 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 right around to laugh out loud, laugh to death funny. So you can program this machine to write a book for you. And it's in kids' popular imagination. So it's not only real, it's in sort of everyone's fiction. Now, I know what you're thinking. You're thinking, I own the robot, therefore I own the output. Or I programmed it, therefore I own its output. Or my robot's not like an unpredictable animal. It's been programmed to do something, it's predictable, therefore I own it. And I'm here to tell you that although a robot, I think, is not sentient yet, you might correct me on that, the legal principles are going to be the same as for the monkey. To answer the question, and look at it from a legal perspective, who owns the output of a robot? There are two questions I think we need to look at, and these overlap. I think they're inextricably linked, and you can't necessarily ask them one at a time. But the two questions is, whatever the output is, would that subject matter be recognised as intellectual property in the first place? And secondly, does IP law actually recognise rights arising from a non-human creator? So those are the two things I want to look at tonight. First of all, though, I think it's really important to just whiz through and have a bit of a talk about what is IP. Because I know that from a legal perspective and from a commercial perspective, we might be largely on the same page, but I think around the edges, we can be sort of at cross purposes sometimes. And so what I thought I would do is quickly just give there's different types of IP, they have different features and characteristics, and they have different pros and cons depending on what you're trying to achieve, and they have different benefits and weaknesses. So I just sort of whiz through a few. The key ones that exist in Australia, I'll probably leave a few out, the really, really minor ones. But the thing I find with that sort of comparison between what lawyers think IP is and what commercial people think it is, a good example is skill and experience is something that I often hear from commercial people. Oh, that's my IP. My employee left and they took all their experience with them, and that's my IP. And lawyers would never think that. We just think you've just got a new job and you're just taking your experience with you, and you can do that. Now that's subject to things like, I don't want to get into employment law, but that's subject to things like restraints and actual know-how, actual trade secrets and confidential information. But because we're not always on the same page, that's what I'm trying to get to, but waffling away a bit. Let's just quickly go through. The two that I'm going to talk about tonight, in particular when we get there, are copyright and patents. So copyright is a right that protects the expression of ideas in material form. So it doesn't protect the idea itself. It only protects it once you put it down in the old-fashioned days, in writing. And copyright has always expanded behind where the technology is up to, and it's always expanded on a piecemeal basis. So copyright started with the invention of the printing press, when all of a sudden it was easy to reproduce books instead of handwriting them. And so publishers were given a right of publication. But it's now, we now have, very helpfully, we have works, copyright works, and we have subject matter other than works. It's nice of the Act to define it, and it's such an easy to understand way. But works are things like literary works, artistic works, dramatic works, musical works. And then an example of a non-work is, it's still in the Act, it's still called, despite the lack of celluloid use these days, a cinematograph film, which is now just regarded as sort of any sort of motion picture. The exclusive rights of a copyright owner include copying. But a new right, which was a digitised right, was introduced some years back, is the right to communicate your work to the public. And effectively that means to upload it or to email it to somebody else. It's an unregistered regime, so the fact that you create something means that copyright subsists in it. Patents protect inventions, and importantly, they don't protect a discovery. And once you meet all the criteria for a patent, the owner has the monopoly on the exploitation of whatever the disclosed invention is. So the quid pro quo is you publish your invention for the public adds to the public knowledge base about what your invention is, but you get a monopoly on it for, in most cases, for 20 years. But there's a fairly high threshold to get that through. Your invention must be, among other things, it must be novel, which means it's never been done before on a worldwide basis. It must have what's called inventive step above the existing technology base. So you can't just have a small incremental improvement on the existing technology base in whatever technological field it is. It has to have a step. And there's some other requirements too. But it's a registered right. An unregistered invention is not protected unless it's confidential, which I probably should have put on that slide. And back in the old days, that's exactly what you used to get. You used to get a piece of parchment, which was a letters patent probably from the Queen or the King at the time, permitting you to do whatever it is you did. We'll get into this a little bit more as we go, when I really want to talk about patents and copyright down the track. But some of the other rights, a design right. In IP law, a design is the shape of a manufactured product. It's not, an engineering design or other design in other contexts. So if you come up with a new, whatever's in front of me, if you came up with a new shape of a new microphone, looks, maybe no one's ever done this shape before, then you might be able to register that as a design. Similar to patents, there's a relatively high threshold to get it through. It's got to be new and distinctive is the language there, but it's quite, in a sense, similar to the novelty concept. Again, it's registered, and an unregistered design is not protected, unless it's confidential, but what's the point of that? Confidential information, I will argue black and blue with you if you are going to tell me it's property, but it's kind of not the point of tonight's presentation, so let's not go down that road. Rather, the law, instead of the information itself being property, the law protects the obligation of secrecy or the obligation of confidence that people have in respect of that property. And the way that that obligation comes about is very often from a contractual obligation. You've all seen non-disclosure agreements, whether they're effective or not depends on how they're drafted or how tightly they operate, but that's the idea. But it can also operate just in equity. So if I whisper a secret to you and say, hey, don't tell anybody, I'm telling you this secret, it's confidential to just us, then the law may be able to step in and protect that as well. Not as confidently in saying that as a contractual relationship, but very importantly, it doesn't protect the information itself. Some of the minor IP rights I thought I'd include here because I don't know what you guys are doing with your creations, so I thought it's probably just worth mentioning them very quickly. In all my sort of career, I think I've dealt with circuit layouts once. It was quite an interesting little aspect of something I was working on once, nothing major, but the layout of a circuit is a unique intellectual property right. It's a bit similar to copyright. It's not registered. Once you create it, it exists because of the fact that you created it.
Is it not under the design category? They have
Could be. I think you might be able to get a design over circuit layouts as well, but there is a Circuit Layouts Act. I've looked at it once in my career. So I don't know a lot about it, but I understand the general concept. And the same with this one. I don't think I've ever dealt with this. I mean, there are lawyers who do. I'm not disrespecting anyone who does this, but I've never come across it in my career. Plant varieties. So I guess the real area where AI might come into this is genetic improvements to plant varieties. Again, this is a registered right. It's not something I personally know very much about, but it exists, so I thought I'd include it. Now, this is quite a major right, but the reason I'm putting it last is because I just don't think it's relevant for tonight's topic. A trademark, and I'll tell you why. A trademark is something that distinguishes your goods and services from those of other businesses. Very, very important. It covers names, logos, slogans, even in less common cases, colours, smells, colour schemes, shapes of products if you're lucky enough to get that through, if it's distinctive enough. But ownership of a trademark is not based on who created it, it's based on which is the first business to use it. So I think that sets it apart from all the others. So I'm going to leave trademarks there. I know that's too small, that's why I gave you a handout to look at. So I know a lot of you have been studying that and poring over it and trying to work out what on earth is Dave going to talk about this for. What I wanted to do is just set up a concept It's very top level. There's going to be omissions and probably inaccuracies in there, so just be aware of that. But it's the idea was to sort of show how does IP step in and protect different forms and contexts of information. And the way I've tried to set it up is I'm not going to talk about privacy tonight, other than to say the left-hand column is to say I'm trying to divide information into sort of two broad categories. Categories about you, personal information, and then on the right, anything else. We've got an overlay at the bottom. I might point over here if that works better. Confidentiality can overlay over the top. And then I've just put copyright, patents and designs. I haven't put the other IP rights up here because I think they're conceptually going to overlap with this, and you'll get it. But if you want to monetize content or information, how do you do it? What can you do? How does the law encourage you, allow you, or prevent you? And that's kind of where I'm trying to get to with this in a little bit. I just hope it's a helpful, useful guide for you. So, personal information up here, your personal information might be your address, your phone number, your date of birth. Some of those things they're not really, I know you don't want to tell people, but they're not really confidential because people can find them out. I mean, people can go and look at the electoral roll. I got a letter in the mail today from a real estate agent who knew I owned my house because they'd looked at the property register. They were just trying to spruik. They were just trying to sell my house for me, but you know, they knew my name and my address. So things like that, it's not confidential in the strict sense, but nonetheless, there are rules about how you can compile, store, deal with, disclose other people's personal information. So that's sort of the top corner there. Then we get into, but it only covers businesses with a turnover of $3 million or more or whatever it is. So I probably should have drawn an arrow going into here for those scenarios. But I think you sort of see what I'm getting at. Down here, if we're talking about your truly confidential medical history or something, information that only your doctor would know about you, then that is getting into sensitive information. It's probably akin to confidentiality for the purposes of this chart. Copyright, I'm going to jump over this for a second. Copyright gives you, as I said, the exclusive role to control copying. It does give you some control over the information, but it has to be in a form that copyright actually protects. The great debate around copyright law some years ago was copyright prevents copying, but it doesn't actually prevent access to copyright works. So I could go into a bookshop and I could pick up a copy of my Artificial Intelligence Robots in the Law textbook, and I could leaf through it, and I could read as much as I want, absorb it into my head and see if I remember it all. I can put it back on the shelf and walk out. I've done nothing wrong from a copyright point of view. The bookshop owner can say, "You're lingering here too long, please leave," but that's a trespass issue. So there was a real debate about how do I protect someone from accessing my copyright work, and that came about with what are called technological protection measures, which is, I've used the word dongles there because there was a case some years back about a mod chip inside a DVD player. So I know it's probably not language you'd use anymore. Patents. Once you've got a patent, you've got 20 years protection. Can't be confidential because you've had to disclose your invention, and very similar with designs. Then you've got your confidentiality overlay here. Copyright stuff can be copyright and confidential. As I said, your personal information can be sensitive as well as confidential. And then you can have just information, which is perhaps not protected by copyright, but it's confidential nonetheless. But that confidentiality can be lost as soon as it goes into the public domain, or as soon as your restraint of trade ends and the relationship between you and your former employer or your former business partner eases up, whatever it might be. But what I'm trying to suggest to you, the long and short of all this is, if you're trying to monetize your content from an IP point of view, you don't want to be here, in that sort of general information not protected by anything category. But, as we're going to discuss, if you don't have a human author or an inventor or a designer, that's pretty much where you're going to end up. So the whole point of this presentation was to say, who owns the copyright or who owns the intellectual property and the output of your robot's creation? The answer is going to depend. We talked right back here about, firstly, is it going to be intellectual property in any case? So that's why we had that big chart on the table, on the screen to work out what it is. And let's jump in and talk about whether the law is going to recognise a non-human creator as an owner, or giving rights to ownership. And so I think the two things I really want to talk about tonight, with all that background and context, is copyright and patents. We're okay for time, Sean? Am I going over, under? If you have any questions, pipe up. I'll either answer as we go, or I'll hold it over for later if I'm going to come up with it anyway, but let's see how we go. Copyright. So my classic example, and you'll have better ones than these, where you've got a drone taking photographs or collecting data or something like that. The Australian Copyright Act says that copyright subsists in original work. I'm going to look at works, I'm not going to look at things that are not works. It's just going to simplify things. But copyright subsists in an original work where the author is a qualified person. And then it goes on to say a qualified person is an Australian citizen or a person resident in Australia. And I don't think we're giving citizenship or residency to robots from an immigration law point of view yet. So it seems pretty clear from that wording, and also if you just look at the context of the entire Act, but in particular that section, if you're not a person, you can't own copyright. But what does it mean to be an original work? And that's something we just need to have a look at. There's a requirement to be original, and that sort of almost, I mean, it's correlative with the requirement to be human in the first place. There's been a couple of cases in Australia which I'll just quickly turn to, but let me just jump in right now and say that data alone, unorganised raw data, is not enough for copyright protection. In any case, even if a human has just extracted it all. So if you don't even get to the point of would it be a copyright work, then data is not going to be protected in any event. And Sean and I were just having a chat before we started over here, and all of the topics we were talking about was heading back to the point where in this space, it's all about data, 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 data. And it's going to do me out of a job as an IP lawyer, because data is not protected by copyright. It might be protected by confidentiality depending on the circumstances, but I can see my role getting narrower, 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 more niche as technology marches on, unless there's some legislative change to what copyright protects. And I've got no problem copyright not protecting data, because conceptually I don't think it should either. There's a general principle also, back to the question I can imagine you might ask, but I own the robot, don't I own its output? In Australian law, there's a concept that what's called shop rights don't give rise to intellectual property rights. So you take your employer's laptop home and you create something on it that's not work related. Your employer doesn't get to own the copyright in that simply because it's a work computer. Or you take your iPhone home and you take family photographs on the weekend. And just because it's your employer's iPhone doesn't mean that your employer gets to own copyright in your photographs taken using that device. Conversely though, if you use your private iPhone to create, or your private computer to create something that is work related, then your employer may get to own it, because if that's what you're employed to do. Now that's all subject to contract, which might override all that, but that's the default setting in Australian copyright law. So there's no shop right. You can't say I own the drone that was taking photos, therefore I automatically, as of that alone, I own the copyright in it. It still requires what's known as originality involved. What about where a person controls or programs a computer to create something? Can that be attributed back to the person who programmed it for copyright purposes? That's something we can think about as we go through. As I said a second ago, the concept of authorship and originality are just intertwined and can't be separated, but they've both got to be satisfied. there's two cases I thought I'd discuss, and there's only been two cases in Australian copyright law that I'm aware of, could be wrong, but that have really dealt with computer created, what's the language in the UK, which I'm going to jump to? Computer generated works. Sorry, it's a very simple expression, but that's where we're getting to. I only know of two cases in Australia. One is, was there copyright in the white pages telephone directory? Remember those things? No one uses those anymore. But a couple of years ago, Telstra thought it was worth fighting about the copyright in the phone book. And I think what happened was a data center overseas got a copy of the white pages or the yellow pages and reverse engineered it and copy typed it all in and created its own rival online white pages. Not, you couldn't call it the white pages, but its own online phone directory. It's what we call it's a whole of universe creation, because it contains every single subscriber of a telephone in that directory, at least almost everybody. I guess you've got silent numbers and people who've opted out, but let's just put that aside for a moment, because it's almost everybody. And is that a copyright work? There's no creativity, in a sense, to put that work together. All you need to do is name, phone number, address, bang, it's done. Alphabetical order, press a button and off it goes. The evidence in the case was that the identity, and you need an author of the work. So who are the authors of this directory? The evidence didn't reveal who the authors were, and it didn't reveal any intellectual effort that the authors had deployed. This went to the full court of the federal court, so it was an appeal case. The telephone directories were, according to the Chief Justice of the federal court, not compiled by individuals, but the automated process of the name of the Genesis computer system or its predecessors. Another judge said, Justice Perham, while humans were ultimately in control of the software, which did reduce the information to material form. So remember, information itself is not protected. You've got to put it in a hard copy, or at least in digital form these days. So while humans were ultimately in control of the software, their control was over the process of automation, and they did not shape or direct the material form themselves, that process being performed by the software. The directories did not therefore have an author, and copyright cannot subsist in them. So that's pretty telling. If you program a computer to do something, and then you say, oh, because I programmed it, the output of it comes back to me, that's a pretty strong suggestion that that's actually not going to be the case from a legal standpoint. The third judge hearing the appeal rejected the idea that the Genesis program was a mere tool used by the employees. So I guess when you're using a computer as a tool, a typical word processor, I mean, the computer is alive and allowing you to work on it, but it's your fingers on the keyboard that are typing the document that appears on your screen. So you're using the computer as a tool to operate. But in this case, that's not what was happening. Telstra had instead supplanted the involvement of authors in the transformative steps of selecting, sequencing, and arranging the listings. So that's where that case ended, and there was no copyright in the white pages. It's a free-for-all. The other case I wanted to talk about from copyright is a case called ACOS and UCorp, if my pronunciation's right, and it's about material safety data sheets. So you know those, if you're dealing with dangerous chemicals, or maybe even not dangerous chemicals, you by regulation you're required to have information about what's in there so people know how to handle it safely and correctly. These two companies were both in that industry, and ACOS had developed a really substantial database of various bits of information about the various components and chemicals and bits and pieces that went into various substances. And the databases contained the data required to generate, around about 200,000 different data sheets. I presume that's all different permutations depending on what you told the system was in your substance. And when access to any particular data sheet was required, the software would call up the bits and compile it together on your screen. So it would create a new document every single time. It didn't have a database of actual 200,000 documents. It would create something new every time. And I'm not quite sure how it came about, but I think UCorp copied some of the data sheets that the ACOS software created, and that led to the legal proceedings about copyright. So was there copyright subsisting in these data sheets? Basically the outcome was that it's quite complex facts. I'm just trying to reduce it quite simply here, but one of the issues was whether sorry, here's the lawyer trying to explain technology to a bunch of technology people. That's why I'm stammering and stuttering around. Apparently what this software did was it created an HTML file itself to compile the various components. And in copyright law, an HTML file is going to be a computer program because it's a set of statements or instructions telling the computer what to do, which is a subset of a literary work. There was no reason to deny that the source code itself was a literary work, but the question was who was the author of it, because the computer was just automated in the way it compiled it. And the judge in that case said, well, it wasn't written by this HTML code wasn't written by a single author. It was generated by a computer program. So really the same sort of issue as the Telstra case a second ago. And the judge also rejected the idea that there was a joint authorship. You know, if there's more than one author of a copyright work, you own the copyright work jointly. But rejected the notion that there was joint authorship between the programmers and the individuals who authored the data for each data sheet in the database, because they weren't actually collaborators, as it turned out, of creating each individual document as it came up. The work that they did was antecedent to the actual work being created each time. So again, the point is the computer generated the work, albeit from a database full of information about all the different chemicals or the substances, and copyright was found not to subsist. A quick case on data. Sorry, I said I had two cases, I had three. No copyright in a data transmission. So some years ago, I think it was the London Olympics, Channel 7, who was the Australian authorised Olympic broadcaster, had a data stream coming live from the UK back to Australia into its control room to then broadcast out to the public as a TV broadcast. And the Commissioner of Taxation was the other party to this case. Can anybody think how that might have come about? Was the data transmission a copyright work on which some form of taxable event occurred? And the answer was no, it was just raw data. So I won't go into all that case, but again, the point is data itself is not a copyright work that's capable of attracting copyright protection unless it's arranged or compiled or ordered in some particular way. And that was just a data stream that just came in. So that leads us back to the point on is the computer being used as a tool by the purported author? So I guess if you're the drone pilot, if you're flying your drone, or to use my previous example, if you're hovering your drone around the paddock or around the field in certain places according to a planned timing, and you know that the camera is going to go off. This is probably completely unrealistic, but humour me. You know the camera is going to take a frame every 20 seconds, and you position the drone to be in exactly the right place at the right time, even if you're not actually pressing the shutter. I guess you might have an argument that you've arranged the photograph and that makes you an author. And it reminded me of a case from quite some time ago, back in the 1880s. Here's me applying an 1880s case about an old-fashioned, what were the cameras called back in those days? You can sort of imagine, the hood over your head as you're peering through and trying to prevent light getting in. I'm going to apply that to some digital technology, but there's a case called Nottage and Jackson, and this was back in the days when photography was new and copyright law didn't really know how to deal with it. The judge in that case says, I know what it means to be an author of something in writing. I sort of think I know what it means to be the author of a painting, even though I wouldn't have called it an author, I would have called it an artist. But how on earth are you an author of a photograph? And they had to work it out. What happened in this case, it was was a UK case, but it had an Australian angle. The subject of the photograph was an Australian cricketer. Maybe there was a tour on that year. Sailed halfway around the world to have a cricket tour. And the photographer's employers were the ones that actually came up with the concept of the shoot and the idea for the location. And the photographer then actually set it up. But the photographer himself didn't, I don't know if he had a shutter back in those days, but didn't actually operate the camera. He left that to his son, but he controlled it. And the outcome of that case was the employers didn't own the copyright because they just provided the concept and the idea. The photographer who didn't actually operate the camera did own the copyright on the basis he was the one who was effectively in control of everything that happened and where the camera was directed at and the timing and whatever else happened. So maybe if we go right back to Naruto the monkey, maybe there's an argument that the photographer set it up hoping that the monkey was going to come along, and he's got all the settings on the camera just so he focused the camera and he hoped that the monkey was going to come and press the shutter because he could predict that was going to happen after 3 days in the jungle. Maybe that's the argument. I've used that photograph on the basis that it is in the public domain, so I hope I'm going to get away with it. But in the UK, and including a few other jurisdictions that followed, they amended their copyright law to say that in the case of computer-generated works, that expression I tried to recall before, the author is deemed to be the person who made the arrangements necessary for the creation of the work. And we don't have that in the Australian Copyright Act. What does that mean? I'm not sure that there have actually been any, at least not high-profile enough cases for me to know about. I mean, is the person who made the arrangements necessary, is that the person who owns the drone? Is it the person who programmed the software in the drone that operates the camera? I don't know. I'm not sure the answer to that. Maybe it raises some other questions. But in any case, I'm going to move on to patents. Does anyone want to talk more about copyright before I move on?
I'm just a bit curious, if you've got something like a music or a film which obviously has shared authorship, the specific definition you gave was very individual. Does that have to be apportioned by agreement? Is there a fractional way?
You mean if there's contributors to the same copyright work?
So I mean the logic there is I'm writing some code, I use some electronic aids to do some cleaning it up and maybe even to suggest some bits, and they say, well, that's 25% of your code. And I've used it, I've controlled it. But
so let me just step back a bit. I'll come back to your example in a minute, because I think what you're talking about is not joint authorship, it's something else. Joint authorship is where there's two or more people who collaborate on the same work. And so it could be, I don't know, I'm trying to think of a simple example.
So I was thinking like a musical song where someone might have done the beat, someone else might have done the word, and someone else might have...
I don't want to use that because the lyrics will be a literary work and the melody will be a musical work. So they're actually separate copyright. Copyright really works in layers like this. You can have different copyrights applying to different things, even though to you it sounds like the same song. But no, let's go to the musical work example. Put the lyrics aside. Just pretend there are none. If you have two people that are both collaborating on the tune, and they both have input on, you do the chorus and you do the verse, or somehow, and it all comes together at the end. You've collaborated on the same work, so then you're joint authors. Now, if the proportion of your input, because the chorus is so much longer than the rest of the melody is, I don't think that matters. You're both joint authors of the same entire thing at the end of it, unless you have an agreement between you that divvies up, apportions your input in some other way, and you agree between yourselves. You can do that. Your example you gave a minute ago, where you've done some code, and you said 25% of the on a quantitative sense, 25% of my code is I've obtained from somewhere else. I don't think that is a co-authorship. You've just borrowed someone else's code, and you've incorporated it in your own work, and potentially that the author of that other code has rights against you for infringement if you don't get permission, or you might just have to pay a royalty or a license fee to that person, and they'll be happy for you to use it, or not. Maybe they're just happy for you to use it, but they're not really contributing to your work because they're not collaborating. They're not collaborating with you to create the single entity of code that you've just created.
So that exists, sure. I was actually referring to, if you imagine you're writing on a Word document or
Yeah.
something, and it suggests a thesaurus or a next word, and you grab that. Then you write the next bit, and it makes a suggestion, and you grab that.
I see.
So I wasn't talking about nicking it. I was saying you've got a tool in your workflow.
I didn't mean you were being dishonestly in terms of nicking it, but I was just covering bases in the
clarifying,
answer.
yeah. Tool that I was referring to.
Yeah. If you took a suggestion from a thesaurus to use this expression or instead of that one, it's still you as the author. You're still making the selection of the word at the end. It's just the computer's just suggesting something to you, I guess. But it doesn't mean that they're a joint author with you. You're still the one creating. Let's go on to patents. There's two halves to patents. One is not really the subject of this talk, but I think we should cover it. Is AI itself patentable, as opposed to the output? Can AI be an inventor? You know, they're two different things. But just very quickly to touch on the top point on the slide there. Is an automated process or a scheme or a method or artificial intelligence, is it itself patentable? The answer is maybe, but it needs to be what's called, to go right back to where patent law started in what's called the Statute of Monopolies, which was the first ever patent law in 1602, thereabouts, very early 1600s, if I've got the year slightly wrong. But the threshold, before you can even look at whether a claimed invention is novel and has inventive step and all those other requirements, the threshold is this even subject matter that's patentable? Is it a manner of manufacture within the meaning of the Statute of Monopolies? So we've got this very ancient concept that's still informing what can be patented in the digital world today. There have been some recent cases on this, and even just a few last year, which have really... I think we're getting to a point where the law is fairly settled, because a lot of people tried it on. You might have heard of business methods, where business method patents, where people were trying to claim patent rights over effectively the digitisation of an old analogue process. So you might have had a filing system using cards and pieces of paper in alphabetical order in a cabinet, and somebody came along and digitised that process and said, hey, great, I'm going to patent that now. And anyone who uses this system has to pay me royalties. That's been tried on a fair bit. And the answer is no, you can't do that. The two sort of key cases that came out last year, one of them was called, the Commission of Patents was one of the parties, because they rejected the patent application. And the other party who was applying for the patent was called ROKT, Rocket, which was, I think, a Singaporean-based company that did marketing and advertising. And they came up with an advertising method using digital technology, which the full federal court found that the disclosed invention was just a marketing scheme. And quote unquote, remember in your patent specification, you have to disclose what the invention is. You can't keep it secret, you have to publicise it. And the level of abstraction to which the invention is expressed demonstrates that it does no more than provide a list of steps to be implemented using computer technology. Not patentable. A couple of years back, I'm jumping here, but a case that really set some of the principles in this area was called RPL Central. And again, it was a case where the Commission of Patents had rejected the application. This was a system to assess the competency or the qualifications of people applying for vocational courses. So I'm not quite sure what it did. Maybe it scanned your CV and then matched it against a database of set criteria or something more sophisticated than that. But again, it wasn't patentable because the computer was not functioning in the nature beyond its ordinary use. And the key principle that emerged from that is simply putting a business method or a scheme into a computer is not patentable unless there is an invention in the way in which the computer carries out the scheme or the method. So it's looking pretty dim for AI in terms of its patentability. There was another case last year, which was Aristocrat Technologies. Again, the Commission of Patents have been pretty active in this space. But this time, this was a gaming company, and they came up with a claimed invention for betting, and it passed the manner of manufacture test on the basis that the disclosed invention was not a mere scheme, but the invention also included some hardware that interacted with the software. So whether it was the buttons you pressed or the console or whatever it was, that was part of the claimed invention. So I got part of this idea of it being just a mere scheme or a business method. Now, whether that gets past the novelty stage and gets assessed as being something that's completely new in the zoo and never been done before, I guess time will tell. But at least they got through the first threshold. Can the invention of, sorry, let me get that around the right way. Can an artificial intelligence system be an inventor from a patent point of view? Well, earlier this afternoon, I probably should have got onto this a few days ago, but I discovered a brand new case, which is spot on. And it sort of wrote the presentation for me, which is great. Nice little ruling from the Patents Office. And I'm just going to go through it because it's really articulate and quite logically presented. So it just helps me. Now, what happened here? Has anybody heard of DABUS? DABUS. It stands for, hang on, there's no way I can memorise this. DABUS, the device for the autonomous bootstrapping of unified sentience. And you can go to artificialinventor.com and read all about it. So the owner of this artificial intelligence device called DABUS is a gentleman called Stephen Thaler. And DABUS has invented, hang on, you can see there I've jumped to the conclusion, but DABUS, this is a screenshot of the DABUS patent application. I'm sorry it's a bit small. This thing apparently is good. I mean, you guys will be able to assess it far better than I can. I'm not technical like you guys are, but the claimed inventor is DABUS. The invention was autonomously generated by an artificial intelligence. That's who the inventor of this thing was. The applicant is Mr. Thaler himself, and he's claiming, I'll get to the point, he's claiming it on the basis that he owns the device, he owns the robot. The name of the invention is if you can't read from back where you're sitting, it's a food container and devices and methods for attracting enhanced attention. I haven't read any of this because I was more interested in the inventorship point rather than what it actually is. But abstract, a container for use, for example, for beverages. It has a wall with an external, and it has a wall with an external surface and an internal wall of substantially uniform thickness. It goes on and on and on and on. But the AI device came up with this. That's the point. And this patent application has been made in a number of countries around the world. And if you go and look at that website I mentioned, artificialinventor.com, you'll see a whole, it's quite informative. There's a lot of information there. What they're doing is they're challenging through the legal system whether or not DABUS, this computer, can be legally recognised as the inventor. Now, some people think that the real reason that they're doing this is more of a lobbying exercise to lobby for greater legal rights for inventions that come about from artificial intelligence and to test out each country's legal system. Because I suspect that they know that it's going to be an uphill battle as they go, but you never know. So what I wanted to do is look at Section 15 of the Patents Act. This is the Australian Act. This is the key section about who may be granted a patent. And sorry, I'm just going to stand in front of the screen because I need to. That's better. I can see my notes here. Excuse me, my eyes are not as clear as today. So what this case was, it's a decision of the Patents Office, so it's not a court decision yet, it's an administrative decision, rejecting this patent application on the basis that it's the very, very, very first foothold of the patent application. The Patent Office has got the application in the door, it's got it out of the filing box and looked at the front page of it and said, what's this? What do I do with it? And the first thing that they do is they check the formalities. So they check all these details just to make sure it all makes sense. It passes muster. And they've obviously looked at this and said, oh, hang on a minute, you can't do that. And they've gone on to a hearing and have come up with this decision. So they haven't looked at all of the merits of the invention at all. In fact, they would say that there are no merits because you don't even clear the first base. But that's how this case came about. So it could be appealed in theory. Maybe it will be. Let's wait and see where it gets to. But so this is a decision of the Deputy Commissioner of Patents, And it goes through. So this is the definition of who can be granted a patent in Australia. Now, DABUS's argument was, well, this says who can be granted a patent, who can be the patentee. It doesn't say who is the, it doesn't define what the inventor is. And very unhelpfully, in this circumstance, the inventor is not a defined term in the Patents Act. Now, previous cases have said you look to the ordinary English meaning of the word, which until artificial intelligence came along, that clearly meant a human, because no one could conceptually conceive of any other circumstance in which there would be an inventor. So this is really testing things out a little bit. But where's my other point? I'm sorry to stand in front of the camera. I've got my back to you. So it's gone through. The word bears its ordinary English meaning. It is clear from section 15 in particular that only a person can be a patentee. However, the entitlement of the patentee flows from the inventor. And absent devolution, which is, thank you. Paragraphs B down to D is how the devolution process. But absent devolution, the inventor will be the patentee, will be the patent owner. So that appears to imply that the inventor must also be a person. So that's sort of the first problem. And then we looked at whether Mr. Thaler could derive ownership of the invention based on paragraph B, C, or D. So we can knock out D, because DABUS is very much alive. Or even if you turn him off, it's not a deceased person. So we can certainly knock that out. And then paragraphs B and C, the problem with these was paragraph B sort of applies in circumstances, for example, if you're an employee and you're employed to invent, or your employment contract says everything I invent is owned by my employer, as is very often the case, the employer gets to be the owner of the patent from the outset. That's kind of the circumstance in which paragraph B might apply. Now, there are other ways in which the invention might be assigned from the inventor to somebody else, but that's a good example, a very common example. The problem we've got here is that a device is not capable of owning property to assign to somebody else. So we failed limb B of the test. And then we failed limb C as well for very sort of similar reasons. Where that's getting to, you derive title from the inventor or person mentioned. One argument that DABUS put up was a really old common law right. It's really interesting where ancient sort of common law rights get applied into IP law. This is why I like this area of law, because the law's always behind where things are up to. And the principle of accession can apply. And I had to scratch my head, I've never heard of that. This goes back to my property law days back at uni. I couldn't remember that. And this is something that comes up in real property or personal property, not intellectual property. So to read the quote, the principle of accession can be relevantly summarised as the owner of property also owns those things that are produced by that property. Right? So going back to I own it, therefore I own what it creates. Great. Back to that argument again. The example it gives here is an apple tree. I own the apples on the tree because I own the tree. Okay, right. It's a sort of a real property example. I'm not sure how applicable that is to this sort of technology. But the hurdle we came to with that argument was very similar. While the principle of accession might well deal with the ownership of an invention created by an artificial intelligence machine, it does not do so by conceptually moving the title from the artificial device to whoever the owner is. And that's the requirement. So the requirement is the person must derive title from the inventor. And so if there's no transfer going on here. So that's where Australian patent law stands. The problem is going to be, I'll come back to that. That's sort of my punchline at the end of it, I guess. But the word intellectual means that at the moment, as Australian law stands, it gives you a very big clue about what IP law is going to protect. Now, what to do about it? If you have some sort of device or a business model that focuses on trying to monetize the output of an automated process, you're back in, after all that, you're at great risk of being up here. Now that's okay if you know that's where you are and you know the circumstances and the consequences of that. I don't mind if you're aware of it. But if you're trying to monetize your content there, you might end up like Naruto the monkey, who gets his first sale, the first sale of the photographs was made to the newspaper, but then once others could access it and obtain it and send it to Wikimedia, it was in the public domain and it ran away. You lost your ability to monetize it from here on. So to go right back to what can we do? I guess these were my thoughts. You might have some others, but your contract with your customer can provide. This is sort of the Naruto point I just made a second ago. It can provide you with revenue with your first customer, the person who commissions you to do something, but it might be difficult for you to monetize it and protect your, not yours, your robot's work from thereafter. If you're aware of that and you're happy with that, well, good, build your business model around that. The confidentiality of it can be protected. So going back to my drone example of a drone hovering over the field collecting data and samples, the data may not be copyright, either because it's just not collated because it's raw data, or because a robot took it, but it might be confidential to the farmer who owns the paddock, or the mine operator whose mine it is you're surveying for where the richest ore is, or whatever it is you're collecting. So it might be that you can keep the content confidential and you can sell access to it. The risk with that is, I guess at some point, this is sort of a theoretical point, the more and more people who buy access to the same content, it's not really truly confidential any longer. Even if you have an NDA with everyone in the world, if they all know it, I mean, it's not substantively confidential anymore. And I think you're running a tough argument to say that, oh, but I want to enforce my NDA against this person when everybody else knows the same information because I told them so. That's going to be a difficult argument, I suspect. I think the third point is probably your best bet. You monetize the provision of your service. So I'm a great drone pilot. I can hover the drone expertly over the field. I can fly it well. I'm licensed, I'm regulated. I've got great insurance in case it crashes. The service I provide is second to none. Maybe that's the better way to conceptualize this, rather than actually selling the content. And inventions, the reason I've said watch this space, let's see what DABUS does. The one thought I did have is that, just standing back here, a person. So you'd think you'd know what a person is. In the Patents Act, a person is not defined, but we have a piece of legislation which is very sensible to have. It's called the Acts Interpretation Act. And what that does, it's an act of Parliament. It was one of the very first pieces of Parliament that was ever passed through the Federal Parliament back in 1901 on Federation. But it tells the courts and tells everybody how to interpret every other bit of legislation that's ever passed. That's actually quite useful. And that says, in any other act, a person, whenever the word person is used, or a word that's similar to it, an individual, a person, whoever, and blah, 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 it includes a body politic or a corporation as well as an individual. So is that your Lenny loophole? Could you incorporate your artificial intelligence system and say, well, it was a person, according to this definition in the Act Interpretation Act? I don't know. I'm not trying to give you ideas. I've got a feeling that's not going to fly. Because the sort of the intention of the Patents Act appears to be very much that an individual has to be the inventor. But you never know. I reckon someone's going to try that out one day. If you want me to run it for you, I guess I will. Come and brief me.
David, do you have any insights into the policy reasons why it has to be a person? Is it just because no one ever anticipated that there would be something that could create things that wasn't a person?
I think so. But there are some pretty sound policy reasons to say, why should a machine own copyright? Practically, I guess it's very difficult to distinguish two photographs, one that's the subject of copyright and one that's not, because one of them was taken by a human and the other wasn't. If you put them side by side, how are you going to know? That's a really challenging problem in itself. I've seen some arguments that say, well, maybe we should give a limited right. So in the copyright sense, we should give a limited right to computer-generated works. Instead of copyright was really intended to deal with great creation, the great great novels and great artistic pieces, and now we use it for, bits of, no disrespect, but bits of source code that are just sort of utilitarian in their application. That's what sort of copyright was intended for. And hang on, I'll come back to you. It exists for the life of the author plus 70 years after you die. So that again makes no sense in the context of an artificial intelligence system. I mean, 70 years after what? But the argument was, should we give a more limited time frame? Should we say, well, a computer-generated work should be protected for 5 years, 10 years, not for the whole life of the author, not as long as Mickey Mouse? And we keep extending the duration of copyright every time the anniversary of Mickey Mouse's expiration of copyright comes about. It went from life plus 50 to life plus 70 some years back. But so that's slightly cynical. But what should we do? There are some real policy reasons for that. Should IP law, as I said at the beginning, is my world as an IP lawyer becoming confined and more niche to human creations? And maybe that's appropriate. Maybe we should be thinking of IP as something that really is up here, it's in your head. Sorry, can I come over here and then...
That's right. Mine's too much of a sidetrack. I'll park it for after.
All right.
I've got a weird sidetrack one as well. So that's okay. We've got a robot on Mars right now.
Yes.
And the opportunity to create anything basically could be out there. Do you as lawyers fear what's coming in that space?
I went to a really interesting online presentation at one of my IP law, sorry, not someone I actually know directly, but IP law colleagues gave a couple of months ago on IP law in outer space. It's really fascinating stuff. I'm sorry, I'm probably not directly answering your question here, but it was really, really interesting. I hadn't paid much attention to this before, but it was talking about, outer space is going to be increasingly commercialized, and if you're on the example was the International Space Station, where different modules have been produced by different cooperating countries. But the International Space Treaty, I'm going to misquote this because I was an attendee at this talk, not the presenter of it. It was a gentleman called Stephen Patterson, who runs a firm called Patterson IP. It was a really good, interesting talk that I went to, just to plug Stefan, not that he knows me, since this is going all over YouTube, right? And he's based here in Perth. The point was that the relevant outer space treaty says that each space module, the national law of the country that registered that space module applies on that space module. So when you've got the space station all interlinked together, when you go from the European side to the American side to the Japanese side to the Russian side, the law changes, which is going to include IP law. So one of the great difficulties, as Stefan pointed out in his presentation, was how do you prove in outer space that someone's patent has been infringed? Because there's no one, if there's no one here to see a tree fall, did it really make a sound, all that stuff. Who sees it, who hears it? So that's going to be an interesting dilemma. But do lawyers fear all this? I think we're pretty excited by it. I am. I think it's really fascinating. My interest in this area of law has always been because of questions like that, and knowing that I've never studied technology or science formally, but I've always just been interested in how the law doesn't keep up with it. It's really interesting to me.
So I am going to go my sidetrack bit. Straight to the other, right? So okay, you've got some high tech thing on Mars, really intense, really high tech, but I would actually create the opposite. So if I'm an artist or I'm creating something and I spend a year on it, it's fantastic, I own the copyright on it.
Yeah.
If my kid spends 3 seconds doing an absolute rubbish piece of masterpiece because therefore and everything's a masterpiece.
Yeah.
As far as the law's concerned,
Copyright subsists.
Copyright's the same.
Yeah.
But if I go to the zoo or Atlantis in the old days and I get a dolphin or an elephant to paint something,
You can go to Perth Zoo and buy elephant drawings now.
that's my question.
Yeah.
No one owns the IP, but the art can be owned. Is that correct?
Well, the physical item
Yeah.
is separate from the intellectual property that subsists in it. So,
So a 2-year-old's art, there's IP, or sorry, there's copyright.
Yep.
But the elephant dolphin one there isn't.
No.
But the property ownership's the same.
Correct. So the physical painting that if you're an art collector, the physical painting you buy is obviously very valuable because it's an original work.
Yeah.
You bring it home, you hang it on the wall. But if you, absent consent from the artist, if you take a photo of it, you've just infringed copyright in it, notwithstanding that you own the physical painting.
Then I have another one. If I have money and I want to hide it, I can do some trust structures and stuff.
I don't know anything about trust, that's not my area of law. Big disclaimer.
Tax office and divorce courts can probably get to it, but for most people it's hidden. Can IP be owned by, can you delve IP into trusts or structures?
Well, yes and no. I mean, IP, if it's a recognised IP right, which comes back to that chart, you don't want to be in that general nothing zone that I was pointing to throughout my talk. But if it's a recognised IP right, then it's personal property, and it can be owned as equally as physical property. Now, what it really is it's a bundle of enforceable rights depending on what type of IP it is. It's the right to sue people for infringement if they do X, Y, Z that's your monopoly. That's what IP right really is. But yes, it can be owned by a company. I can buy and sell it. I might. There's a curious type of copyright called a work of artistic craftsmanship, which is really intended for sculptures and. So I don't think this is creative enough to be a work of artistic craftsmanship. But let's just say it's such a masterpiece it is. I can sell my copyright in this to you, but I can still take home this physical object and keep it as my property. But you would now have the right to prevent other people from making one of these. It doesn't prevent me from owning the physical item. It already came into existence before I assigned it to you, but you could prevent other people doing it. But I'm not giving up my royalty anyway.
Question follow on his question. Is it put you in the trust and then become a perpetual life of ownership?
Well,
you don't have the end.
So to come back. Sorry. Let me just come back. So can you hide it? Well, a registered right. No, you can't hide that because it's registered.
Yeah.
I guess in a trust situation, it would be registered in the name of the trustee because that's where the legal ownership is, and who they're holding it on trust for. Does that have to be disclosed in the register? I'm not sure that it does. I say on YouTube.
Do you know where you can see where I'm going?
But copyright.
I'm a corporate trustee.
Yeah, but copyright's not a registered right. You can assign copyright from one person to another. Again, that can be held on trust for the benefit of someone else. And what that really means is if the copyright is performing economically, then the income you generate from the copyright is really what's being held on trust for somebody else. Sorry, back to you. Was that?
Yeah, just normally the trust is a perpetual life. So, what is the life of the copyright then?
Well, you put trust aside a minute. IP law, depending on what type of right it is, they all have finite lives. Nothing lasts forever. Maybe confidentiality, but that's not a property right. It's a relationship. So, copyright lasts for the life of the author plus 70 years in most cases, but in other cases it can be less depending on what it is. A patent lasts for 20 years. A registered design, the shape or appearance of something, lasts presently for 10 years. There's a law reform or a report recently that recommended lengthening that, but I don't think that's going to happen just at the moment. A circuit layout right, I don't remember. I think it might be. I'm not even going to attempt to answer for that because I just don't recall. Plant breeder rights also have finite life. So they all have a finite life. So when the right's life ends, it just enters the public domain, and you're back in that general free-for-all zone. So as soon as the patent ends, anybody can use the invention and exploit it without permission from the previous patent owner. It's over. The monopoly is for a limited period. So even if if you do hold IP in a trust, then the trust might continue, but the IP right will conclude because that's the end of its life.
I got a question. Is the language matter for the IP protection? Because, for example, we programmers, what we're doing is we're writing algorithms to do something.
Yeah.
Okay?
So computer programming language.
Yes. Like something simple to move one glass from this position to this position.
So
what is happening is we use some kind of language of
yes.
and I want to protect
yes.
The algorithm. But obviously, to protect the algorithm, so I need to make it public.
So no, not quite. So you're right, the computer language matters.
Yes.
Copyright protects the expression of your idea in material form, however you express it. I'll come to computer programs particularly in a second, but let's say a couple of you in this room share the same idea, whatever it is, and then you both reduce that idea to painting, to artistic form. You're going to come up with very different paintings, I assume. I certainly know that when my kids at school are told to draw a picture of XYZ, every kid in the classroom is told to draw a painting of XYZ and they all look different, right? Because they're all creative in their own different ways. So copyright will equally subsist in each of those paintings, even though it comes from the same concept or the same instruction. So that's sort of the first point. I mean, even if you both come up with two works based on the same concept in parallel, then copyright equally subsists in each of them. It's very unlikely, outside computer programming perhaps, but it's very unlikely that your two paintings would look identical to each other. But even if they did, because you came up with them individually, and neither of you copied the other, let's say, then copyright still subsists in each of those individually. Now, to come to computer programs, it's an interesting category, and there's the reason that computer programs were included as a type of copyright, I assume, was back in the 1980s, I think, when computer programs were like basic, line 10, print XYZ on screen, line 20, go to line 10, and it was all sort of human readable even to lay people, and that's why it was considered to be a literary work, and it just got bundled up as a subset of that. I think there was an argument at the time that it should be a sui generis, a unique right of its own, but that's not where it ended up. But of all the copyright rights, computer programs are the only things that are functional, and that's really interesting. Your painting's not functional. It's nice to look at, but it's not actually functional. A book is not functional. I mean, it gives you information when you absorb it, but it's not a functional thing in itself. But a computer program is, and that's really interesting. But it still comes back to the expression of your concept. So whatever the instruction is that you're trying to give the computer, you're trying to make the computer do, the way you express that in code, it's not the concept or the functionality that's actually protected, notwithstanding that computer programs are effectively functional. It's the way you express it. So yes, if you express an instruction to a computer in one language, and another programmer gets the computer to do the same functionality using a different computer programming language, they're different things. And copying the functionality of your computer program is not an infringement. They would need to copy the actual code. I was involved in a case as a junior lawyer a long time ago where that was actually an issue, where the question was, had someone come along later in time and they'd reprogrammed this computer program, the functionality of it, but in a computer, I don't remember what it was now, it was 20 years ago, so, but in a completely updated, superior computer language to the one that had been used previously. And the argument was run that, but you infringe my copyright because you've rewritten this computer program that does the same thing. But as soon as it was found to be in a different programming language, that falls away.
Yeah, because that's the point. We used to use different languages, so there is Python, so different them. So what is happening is, so at this point there is not a way to protect practically the algorithm.
Well, the way to protect it is to assert. I mean, you can't register copyright in Australia. In the US, you can. I don't know a lot about how that works, but you can. I don't think you have to, but you can. Here in Australia, you can't. Copyright subsists merely because you create something and you reduce that concept into brush on canvas, pen on paper, fingers on keyboard on screen. So as soon as it's in the memory of your computer or saved as a file, it's probably even less than that. But as soon as you've reduced that to a material form, then it's protected as copyright.
Does that mean that if two separate AIs happen to create exactly the same thing, but they're different AIs, that means they're not infringing each other?
If they're completely independent of each other, then, I mean, putting aside all the issues we were talking about earlier, yeah, sure, they can coexist. But in a copyright sense, they can. Patents are different because patents give you a monopoly once you've disclosed it. And once you've disclosed your invention, if somebody else comes along and perhaps they don't know about your patent. If they come along and say, hey, I've come up with this great invention, I'm going to go and register that as a patent myself. If they discover that you've already done it, well, notwithstanding that they somehow didn't know about you, it's too bad. The one that's come along second in time is no longer novel, and so it fails the novelty test. I guess the exception to that, sorry, I know there's questions over here. The exception to that is where the first invention was kept secret and hasn't been registered as a patent. That's possibly where the second in time might be able to gazump it because it gets assessed and published first, maybe. But generally speaking, if you're second, notwithstanding that you had no reference to the first one, you're still out of time because it's not novel. Sorry, there's two hands over here.
A choose your own adventure novel, would that be considered as a creative work or an instructional work?
Good question. I used to read those when I was kids, are they still around? I think it's just a literary work. Because it's not making a machine do something, it's just making the reader go to a different page out of sequence. And you don't have to if you don't want to. It's not a good outcome if you read it out of order, but that's what can happen.
I have a conundrum. So basically, for the patent law of how it has to be a person, is it for liability and accountability? For example, like if you have an AI, you feed it information, it generates instructional sets for people to follow, and if it accidentally leads to like a loss of life, then the AI can't be really accountable.
Well, that's getting into a whole different territory outside IP law, and it's a really interesting area. I'm going to have to turn to what's really interesting about this book is it's got a chapter on all that sort of stuff, liability and negligence and stuff. There's no chapter on IP law in here. It's really interesting. I'll have to write it for next time. The answer is really complicated, and it's really an insurance lawyer's question, but I guess insurers need to come up with new insurance products to cover this sort of, what sort of scenario, I guess. That's one of the answers. But who's liable? I guess the person who sets it free is potentially liable for the damage it does, even if there's no IP subsisting in it. I mean, they're completely different legal issues.
Yeah. Because I was thinking there's no IP for the instruction set that produces, but...
No, but it's still functioning. I mean, are you looking at the timing? Okay. Yeah. I think you can still apply the general law of negligence to whatever the robot is doing. If it's causing foreseeable harm to somebody to whom you owe a duty of care, then quite potentially you're liable for setting it loose, I guess. Is that the right expression? It's not a legal term, but...
But David, with that leading to, if the algorithm is biased to a certain group of people, is it that can crossing that liability occur?
I don't know. I don't know. Conceivably, yes, but I think it's going to be, like anything, it's going to be very factually dependent.
If you had to hazard a guess as to which country or jurisdiction in the world would be easiest to get IP to be owned by machine agents, obviously not Australia, what would be your guess?
I don't know. I'm not as familiar with some of the other jurisdictions' rules as to answer your question. I think it's probably a wait and see exercise. The artificial inventor website I mentioned before, it's probably going to have your answer in there somewhere. I haven't read through it in enough detail. They've tried a whole lot of different jurisdictions to get that container patent going, but I have a feeling it's been knocked back everywhere so far.
I'm pretty sure a few years ago that was knocked back in the UK and the US. I'm sure I've heard that exact one. I'm curious if it might be a slightly different.
I think it's going to take a bit of work to get through. So until somebody uses my linear loophole idea, which I'm not very confident about, by the way, of incorporating your device and saying it's a person according to the Acts Interpretation Act, I think that's a little bit too clever by half, so I don't see that happening.
And on that, so if the robot on Mars creates works.
So going back to the space law presentation I listened to, the answer I think is going to be, I don't know enough about this either, but that space module or space rover is presumably registered under the Earth-bound Space Treaty to a certain country. Therefore, the laws of presumably the US, I guess in that case, apply to that rover. Interesting. But if they're just sending a raw data stream back from the Mars Olympics, the taxman's not going to mix on it. To mix up our cases. I think I was getting a wind up, so is there any more? I'm going to stick around so you can have a chat.
I think we're good. So
excellent.
Absolutely awesome talk, Adam.
Thank you.